Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, was not able to get this video out yesterday. Huge news yesterday. Would have loved to get a video. We had our Freedom Friday event at Security Gun Club, raising money for the challenge to Washington's assault weapon ban. Proud to announce that we raised over $10,000, but we had huge, and I do mean huge, news come out of the Southern District of Illinois yesterday in a ruling that we're going to talk about today. I do want to point out that this video is dedicated to Illinois State Representative Bob Morgan right here. This is how Bob celebrates stripping its citizens of their inalienable God-given rights, by the way. But there is a ruling that came out of Illinois that has huge implications on assault weapon bans, magazine bans, and even a pistol brace rule. Not like we've been talking about any of that stuff lately, right? So today, finally glad to get back onto a national topic, so let's spend a few minutes and talk about huge trifecta out of Illinois and what it means for us moving forward. Okay, so the case we're talking about, and I know a lot of people got out in front of this yesterday in the YouTuberverse, is Harold v. Raul. Okay, it's a case out of the Southern District of Illinois. Now, as we know, back on July 4th of last year, there was a horrific mass shooting at a 4th of July parade in Illinois. That, of course, got the Illinois State Legislature to take an innocuous piece of insurance legislation, which had kicked around in committee for about a year, absolutely strike everything from it, turn it into an outright ban on all semi-automatic rifles, as well as high-capacity magazines, not notify the public at all, pass it through the House, the Senate, and signed by the governor in just a little over 48 hours. Sounds crazy. It could never happen in the United States. Well, it could happen in Illinois, and that's exactly what happened. That, of course, led to a ton of lawsuits being filed on this, and we've seen various rulings of varying degrees depending on the political jurisdiction, including, of course, we've also had to cover some of the other rather overt corruption that's going on in the state of Illinois. The court here, the Southern District of Illinois, was not particularly impressed with the Protect Illinois Community Act, despite the fact that it was in response to this very tragic shooting. And I'm going to read this quote from the opinion, and it's a longer quote than normal, so bear with me here, but I think it really kind of bears out where the judge was going with this. As Americans, we have every reason to celebrate our rights and freedoms, especially on Independence Day. Can the senseless crimes of a relative few be so despicable to justify the infringement of constitutional rights of law-abiding individuals in the hopes that such crimes will then abate or at least not be as horrific? More specifically, can PICA be harmonized with the Second Amendment of the United States Constitution and with Bruin? That is the issue before the court. The simple answer at this stage of the proceedings is likely no. The Supreme Court in Bruin and Heller held that citizens have a constitutional right to own and possess firearms and may use them for self-defense. PICA seems to be written in spite of the clear directives in Bruin and Heller, not in conformity with them. Whether well-intentioned, brilliant, or arrogant, no state may enact a law that denies its citizens rights that the Constitution guarantees them. Even legislation that may enjoy the support of the majority of its citizens must fail if it violates the constitutional rights of fellow citizens. For the reasons fully set out below, the overly broad reach of PICA commands that the injunctive relief requested by plaintiffs be granted. Okay, so as we know with all of these lawsuits in Washington, you need to pay attention to this because we're about to go through the same old rigmarole here. Though one of the first things the plaintiffs are going to do is they're going to ask for an injunction. What is an injunction? It's a big fat pause button on the implementation and enforcement of the law. If an injunction is granted, it basically ceases the law to be enforced and allows people to live freer. Now, it's the state of Illinois, so I'm not going to say free like Americans, but freer, more similar to what Americans should live like. Now, the case law on injunctions is pretty similar throughout the country. And again, to break it all down in just really simple terms so we can all understand, there are really two things that a plaintiff must show in order to get injunctive relief. The first thing they have to show is that I am suffering irreparable harm, okay? Now, the state of Illinois was quick to point out and say, hey, no, you're not suffering irreparable harm. We're banning some accessories. We're banning a few firearms from you, but you can still have the right to keep and bear arms, just the firearms that we say you can have. So there's really no irreparable harm. Now, the court was obviously not persuaded by that, and this is how they responded. When a law is facially challenged under the Second Amendment, the form of the claim and the substance of the Second Amendment right create a harm that is properly regarded as irreparable and having no adequate remedy at law. So the court properly found that the mere allegation of a violation of a constitutional right constituted irreparable harm. Now, the other thing, and this is really important, the other thing that a plaintiff must have to show in addition to irreparable harm is that they are likely to succeed on the merits. So when you see injunctive relief being granted on cases, the cue to take from that is hey, this is a good argument that the plaintiffs have, and the court is pretty much persuaded at this point that they're on the right side of the law. Now, the court here engaged in an absolutely proper one-part analysis, which is, does the activity that is prohibited here, is it covered by the text of the Second Amendment? If the answer is yes, then of course it is presumptively unconstitutional, and it becomes the government's burden at that point to establish that there is a historical analog that demonstrates that we as a nation have accepted this type of regulations in the past. Obviously here, the state of Illinois failed miserably, and they failed miserably because no such historical analog exists. Okay, now, one of the arguments that the state of Illinois said is hey, they're not necessarily banning a bunch of firearms, they're just banning a bunch of accessories. And accessories are not arms, and therefore there's nothing in the Second Amendment that protects them. The court clearly was not persuaded by that when they responded as follows. Defendant's argument is not persuasive. The Seventh Circuit has recognized the Second Amendment is extending to the corollaries to the meaningful exercise of the core right to possess firearms for self-defense. It is hard to imagine something more closely correlated to the right to use a firearm in self-defense than the ability to effectively load ammunition into the firearm. The Third Circuit recognized the importance of this corollary and held that magazines are arms under the Second Amendment. This court agrees that magazines are arms as used in the plain text of the Second Amendment. So this is a huge ruling. Now, it's consistent with other case law, but for all of the states currently fighting both assault weapon bans as well as magazine bans, sound familiar Washington, sound familiar Oregon, sound familiar California, this is exactly as the law should be applied here. But there was an extra little nugget, a really nice little nugget in this opinion, because apparently the Protect Illinois Community Act also outlawed arm braces. My God, who would ever think of trying to regulate and outlaw arm braces? That's crazy, isn't it? Well, the court pointed out that that probably was unconstitutional as well, due to the fact that arm braces were obviously designed to help those with disabilities. As the court put it, as reason in the ATF final rule evidences, braces are needed by certain individuals with disabilities to operate a firearm. Thus, arm braces are an integral part of the meaningful exercise of Second Amendment rights for such individuals and can also be considered an arm. Now, one of the other arguments that the state of Illinois makes, and we see this with all of these gun-grabbing blue states, is that, all of the accessories we're trying to ban really just make these firearms more deadly, and we're just trying to create a less lethal firearm so they can't be used in mass shooting. Put in more tactical terms, what we're trying to do is make people less proficient and less accurate with these by banning these accessories. Because as we know, all of these accessories are there to help a shooter be more proficient and more accurate with a firearm. Now, accuracy is really important in all areas of shooting, but when we're talking about self-defense shootings, accuracy seems to be a really critical component. The court was also of that mindset when they stated as follows. This court agrees that in the case of each of these items, the defensive application is obvious, as is the public safety advantage in preventing stray shots. And so ultimately the court found that this needed to be analyzed under the common use test, which is exactly the analysis that we should be using. Now, many of you have already heard me talk about the common use test, but essentially what it comes from the Heller opinion, and it basically says, listen, the only historical tradition that we have in banning firearms are firearms which are both dangerous and unusual. Not dangerous or unusual, dangerous and unusual. And it's the unusual component that the government is always going to have a problem proving when it comes to these particular platforms of firearms. The court even so much as pointed out that, listen, in the case of Catano versus Massachusetts, the Supreme Court found that the existence of 200,000 stun guns made them in common use, and therefore they could not be banned. Well, if 200,000 stun guns constitute common use, what does 24.5 million semi-automatic rifles constitute? The court also made a similar finding into what the state of Illinois calls high-capacity magazines. The rest of us call them standard-capacity magazines, when the court pointed out that there were approximately 39 million owners of high-capacity magazines nationwide, which is about 3 times the population of the state of Illinois. And Illinois, I believe, is the 5th or 6th most populous state in the entire United States. So when you have ownership 3 times the amount of your state's population, and you're not Wyoming, that typically means that, yes, these are, in fact, in common use. Okay, now the state of Illinois has already crapped its pants. Their attorney general has already appealed this case up. It happened in less than 24 hours. We know that they're going to have a big old pissing contest because, dang it, they believe they're right. The problem is the law and the Constitution does not work for them. This is a huge ruling out of this court. This has the potential to have huge implications moving forward. I think you're going to see very similar lines of reasoning being authored by other opinions. I think that we may have a huge ruling coming out of San Diego in the near future that may also read quite similar. The case, once again, is Harold v. Raul. We'll put the links for it down below. It's a huge, huge victory for all of us in the 2A community. Kudos to all the plaintiffs' counsels. You guys did a fantastic job in this. It's an incredible piece of lawyering. Listen, if you got any other questions about this case or anything else related to what's left of our Second Amendment rights, you guys should know how to contact Washington Gun Law by now. But if you don't worry. All of that information is right there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.